It's really a pleasure to be here today. We're going to speak specifically about building electrification efforts in the US and the legal frameworks and potential issues that apply to local governments as they're thinking about building electrification or so-called natural gas ban policy. I'm going to provide a kind of overview of local options or local precedents for what we've seen before in this space in the US. And so, some of this will be very relevant to your jurisdiction and some of it will not be. You're all from different places. And in the US, we obviously have 50 different sets of state law and, even more sets of law that are applicable to local jurisdictions within those states. But this will help give you a sense of how other local governments have navigated the building electrification space from a legal perspective. So, I'm sure over the last 2 to 3 years, you've seen all sorts of headlines about cities, quote, banning natural gas from new buildings. The movement started in Berkeley in the summer of 2019. Brookline, Massachusetts, later that year, came along and attempted a natural gas ban, and dozens of other local governments in California and a handful in a few other states at this point have either banned natural gas or imposed building electrification requirements for new buildings. I want to note before we proceed that I sometimes use the terms natural gas ban and building electrification interchangeably. They are not exactly the same thing, but they are flip sides of the same coin policy-wise. So you'll often see these policies referred to together. Sometimes, some folks think building electrification is sort of a more palatable political form of messaging. And I think for that reason, a lot of us are moving away from the term natural gas ban, but it's, it's just so pithy that we use it a lot. But if you think about it, they're really two sides of the same coin, right? So if you require that buildings are built without access to gas lines, then everything inside the building will need to be powered by electricity. And if you require that buildings are built all electric, then no gas line will be needed. So there's a difference in some of the legal mechanisms that are used to accomplish these goals, but the end result is more or less the same. And so sometimes I switch back and forth between the terminology and so might others. A lot of times headlines will say natural gas ban when actually what they mean is building electrification reach code. So, I feel like it's always worth stopping for a second to remind ourselves, why do we want to phase out natural gas from buildings? And so first, obviously the climate reasons, building emissions reductions are obviously key to any local government's climate action plan. Buildings account for about 40% of greenhouse gas emissions in the US. In some of your communities, I'm sure that percentage is far, far higher. And building electrification is one of the key ways in which we will decarbonize our building stock as a whole. We've got to make buildings as efficient as possible. We've got to make sure our electricity is supplied by clean energy, and then we've got to make sure our buildings are electrified to make use of that clean energy that's on the grid. All of these have to happen more or less in parallel. And while states and the federal government are the ones that are, most able to as a general matter, are most able to help to green the electricity supply or green the grid, local governments are the ones that have sometimes more authority over the efficiency and electrification components of buildings. And obviously new buildings are a great place to start. Probably don't need to convince anyone on this call of that. They're also really increasingly, I guess, we're seeing really public health reasons for electrifying buildings. I don't know if someone's off of mute, but if you could put yourselves on mute, that would be great. We are, increasingly seeing data about kind of these really, significant public health burdens from natural gas-fired appliances. There's indoor air pollution and outdoor air pollution, and some of these appliances, stoves in particular, but not exclusively, they emit really gross stuff like particulate matter, nitrogen oxides, formaldehyde, all sorts of other chemicals that cause really bad health outcomes. And so, even though for a long time we were sort of like gas appliances are fantastic, as it turns out, they can be very, very unhealthy. And this in particular can be an equity issue, particularly in apartment buildings and smaller homes that are less likely to have adequate ventilation. So I use the term legal pathway a fair amount. And what I mean by that term is a law or set of laws and legal tools that can be used to advance an identified policy goal. And here, of course, that policy goal is new building electrification or the restriction of natural gas for new buildings. So we're going to talk through the legal pathways that have been used by local governments in the US so far to regulate gas use in new buildings. And not all of these are going to work the same way in every jurisdiction, but they'll provide a lay of the land. I can't promise that this will answer all of your questions, but hopefully it will help you at least start asking the questions you need to consider as you figure out building electrification, how it might work in your jurisdiction. I'm happy to take questions. If you want to interrupt me with questions, that's fine. We also can take questions at the end. I guess we're recording now and not recording later. So to the extent that matters to you, that's the case, but happy to take questions. So I've listed the legal pathways here, and we're going to go through them one by one. I want to note that many of the policies that we'll talk about have exceptions, they have varying timelines. There's, quite a bit of like community specific nuance. Some of these policies exempt kitchen stoves, commercial kitchens, hospitals, lab space, a lot of it has to do with politics. Many of them exempt backup generation, so you could have a natural gas generator. Some apply, only to commercial or residential or phase in over a certain period of time. So, we're going to gloss over basically all of that nuance to focus on local authority to actually pass these codes or requirements. But, if you go forward to develop one of these policies, you can dive into some of this nuance a bit more. So first up, in terms of legal pathways, is the direct prohibition on gas lines to new buildings. And this legal pathway is really the closest thing to a quote, natural gas ban. Even though, like I said, we use that term sometimes to describe other legal pathways as well. Generally, in doing this, local governments rely on their police powers or their authority to regulate with respect to resident health, safety, and welfare to justify these prohibitions. And they generally have attempted to not regulate anything kind of within the building itself. They regulate the gas line that extends right up to the building. So they're kind of avoiding building code preemption, or trying to, in that sense. Berkeley, California, like I said, was the first municipality in the US to ban gas or to promote building electrification at a community-wide scale back in the summer of 2019. And it got a bunch of headlines for doing that. And with a handful of exceptions and opportunities for variances or waivers, Berkeley has prohibited gas line extensions to new buildings. And in so doing, it relied on its police power, which all of you are local government people, refers to as state or local government's authority to regulate with respect to the general health and welfare. So you can see in the law's legislative findings, this is actually, screenshotted, pulled directly from Berkeley's natural gas ban. You can see in the legislative findings that Berkeley really relied on, its authority to regulate with respect to health and safety and the general welfare. It describes Berkeley as vulnerable to sea level rise, experiencing the repercussions of excessive greenhouse gas emissions and rising sea levels, wildfires and firestorms, earthquake risk, local air pollution, lower heating and cooling loads from heating bills from all electric construction. So this is really how Berkeley justified its natural gas ban. It really sort of relied on its public health authority. I do want to note that Berkeley is facing some litigation with respect to its natural gas ban. There's a restaurant industry group called the California Restaurant Association that brought suit against the city of Berkeley, alleging that Berkeley's prohibition was preempted by federal law. And the US District Court ruled in favor of Berkeley, upholding its ban, saying it was not preempted by federal law, but the Restaurant Association has appealed to the Ninth Circuit Court of Appeals, which here in the US is our second highest court. It's the one just below the Supreme Court. I won't bore you with all of the procedure, which there was a lot of in this case, but effectively the US District Court judge, which is the federal trial level court in the US, in the Northern District of California, considered the merits of the federal claim, and which was alleging preemption by the US Energy Policy and Conservation Act, or EPCA. So, we could set aside a whole other session on EPCA preemption, but EPCA expressly preempts state and local standards concerning the energy efficiency or energy use of certain common building appliances like furnaces and HVAC systems. And so the CRA, the California Restaurant Association, was essentially arguing that Berkeley's gas ban effectively set this kind of standard, this kind of energy conservation standard, and therefore should be preempted by EPCA. The judge disagreed, and the case is currently before the Ninth Circuit. Hopefully the Ninth Circuit will follow the district court's lead and find in favor of Berkeley, but if it goes the other way, we may need to consider whether this federal law and what this case might mean for a Berkeley-style ban. I'm going to check the chat quickly. Oh, I will get back to you later, Leslie. Sorry. Okay. So Brookline, Massachusetts, it's a very small town outside of Boston. They also followed this direct prohibition legal pathway, and they ran into hurdles with it. So unlike Berkeley, Berkeley's facing litigation, but basically the ban is in effect. It's working there. Brookline, Massachusetts has run into legal hurdles much sooner. They've not been able to put the ban into effect. So, like Berkeley, Brookline carefully structured its prohibition to avoid preemption by relying on its state-granted home rule authority. And I've pulled out the particularly relevant pieces of that home rule law in Massachusetts. So, they have an express delegation of authority with respect to the internal police, which is a fancy way of saying the police power or the public welfare, and to supposedly the regulation of pipes and fittings for gas. But Massachusetts has this kind of quirky law on the books that requires local governments who are organized in the town form of government, as opposed to the city form of government or county or whatever. Towns have to submit their proposed local laws to the state attorney general for review and approval. And unfortunately, the attorney general struck down Berkeley's natural gas ban, determining that it was preempted by 3 state laws: the statewide building code, the statewide fuel gas code, and the state public service law. This is not necessarily the last word in Massachusetts. A local government that's organized in the city form of government does not have to submit its proposed local laws to the attorney general. So a city like Cambridge or any other city could try and enact a similar law and see if anyone sued them over it and then duke it out in court. Brookline could have appealed the attorney general's ruling or challenged it, and they chose not to do so. But this effectively sent Brookline back to the drawing board. I hate to end this legal pathway. It's a downer. I want to note that Brookline's legal hurdles are very specific to Massachusetts state law. It has nothing to do with how a ban would fare in other states. It's doing just fine in California. So I think this is very much a legal pathway that is open and available to other local governments. So the second legal pathway that I'll highlight is the all-electric construction code, which requires or strongly incentivizes new buildings, or in some cases, substantially renovated buildings, to be built to an all-electric standard. So everything in it has got to be powered by electricity, and therefore, no gas or other fossil fuels. This is far and away the most common approach by number of local governments. So dozens of them in California have done this at this point. Probably some of you all on this call, your cities or towns have done this. It is admittedly a lot easier for local governments in California to exercise building code authority than it is for local governments in many other states. Seattle is doing this for commercial building construction. A handful of other local governments are considering it really an option for local governments that have ample building code authority. So what a local government is doing here is using its authority to regulate building construction in various ways, to require a building to use only electricity, or to offer incentives for buildings that use only electricity. A common formulation would be to require buildings built with fossil gas connections to meet a higher efficiency standard, although that's not universal. So, I know there are probably a number of you on this call thinking, well, we don't have building a code authority, right? So what are we going to do? And unfortunately, this legal pathway is pretty binary. A number of state building codes preempt local building codes. And so that's, going to be somewhat the end of the inquiry on this particular legal pathway. You could consider whether your state allows for any petition to the state building code authority for a local exception or something to that effect, allowing you to amend the building code locally. Many states do have such a mechanism in place. But yeah, this is a legal pathway that is a great one for local governments with code authority, and probably not a great one for those without it. So because I'm a lawyer, I will just point out a very small amount of legal scrutiny that these codes have encountered. A couple of home builders sued a couple of small towns in California over their all electric codes. And, I don't think these suits particularly had merit. But I do want to recognize that lawsuits can be costly for small communities, regardless of their merit, right? So in Windsor, California, the town actually opted to get rid of its all electric code amendment rather than fight the lawsuit because it would be so costly. So the third legal pathway that I'll just share is the use of air pollution control authority that some local governments have. I mentioned in the first couple of slides, gas appliances emit a great deal of local air pollution, things like NOx, particulate matter, formaldehyde, chemicals, and particularly when they're not well ventilated. And, of course, they emit a ton of carbon pollution and a significant amount of methane pollution. And so some local government bodies, cities, counties, towns have a good amount of authority to regulate air pollution. And this is a legal pathway that I'd really like to see get, kind of far greater use than it has. There's really a huge amount of potential to reduce local air pollution and greenhouse gas pollution by phasing out gas burning appliances. So far, the only building electrification or fossil gas phase out effort that I've seen to use the air emissions legal pathway is in New York City. The city is amending the building code to limit the amount of greenhouse gas pollution per measure of energy that a new building can emit. I would, in particular here, consider the relationship between city authority, county authority, if there are differences in your state. In some places, counties have very broad public health authority and other cities have it. So you might want to think about complementary authority in the air pollution control space. It's really, I think there are some real parallels here to phasing out smoking in public spaces. It was local governments that really led the way on prohibiting smoking in indoor and some outdoor spaces based on this public health authority. And so there are some real overlaps here with the dangers presented by gas combustion. So the fourth legal pathway that I'll highlight is for local government to use its zoning authority to incentivize gas-free construction. An incentive could come in a variety of forms, a density bonus, a size bonus, a break on fees or another requirement, expedited permitting, all these sorts of things. This is the same as if a local government were to allow a density bonus for LEED compliant building, for example. So far, this has really only been attempted in Massachusetts. Brookline, you'll remember, is the small town that enacted the gas ban we discussed a few slides ago that was struck down by the Attorney General. So after it was sort of, sent back to the drawing board by the Attorney General, the town enacted 2 zoning code amendments. One that offered incentives for fossil fuel-free construction in a particular overlay zone in a particular area of the city or town, and another that applied only to buildings seeking special permits. So for buildings that were built with gas connections, those buildings would be offered a special permit that expired in 2030. And for buildings that were built without fossil fuels, they would receive a special permit in perpetuity, essentially. Unfortunately, the Massachusetts Attorney General also struck down that effort by Brookline. But still, I wouldn't let this discourage you. The Brookline decision was very specific, again, to Massachusetts law, to a specific provision of state law that dictated what should go into a zoning code versus what can go into a building code. And Brookline has actually appealed the Attorney General's decision there, indicating that they think it is a weaker decision by the Attorney General than the initial decision about the 2019 natural gas ban. So if you're a jurisdiction that offers height or density bonuses, for example, for any sort of attribute that you are looking to encourage, LEED construction or something similar to that, even affordable housing, right? This is another area where often we offer zoning bonuses for affordable housing construction. This is very much in line with that. I think there's a lot of potential for zoning incentives to work for building electrification. So the last legal pathway that I'll mention just quickly is state advocacy on building electrification. There are obviously a lot of forms that advocacy can take, but just to focus on a couple of the legal tools. For those in home rule jurisdictions, a home rule petition to the state legislature can be an option, right? About half a dozen local governments in Massachusetts have filed home rule petitions with the Massachusetts state legislature. This was in the wake of the Attorney General's decision about Brookline's gas ban. Those petitions are still pending, but they haven't been voted down, and they do seem to have led to other positive outcomes at the state level in Massachusetts. Of course, home rule petitions might not be super simple for you. They can be politically fraught, certainly, but they can be a useful advocacy tool. You could also advocate for state legislation that either imposes building electrification requirements or that clarifies that local governments can impose building electrification requirements. A couple of things have come out of this kind of advocacy. In Massachusetts, the state's 2021 climate legislation directed the building code authority there to develop a net zero stretch code that local governments could opt into if they wish. Unfortunately, I don't think that net zero stretch code is going to be as strong as advocates would like. It's probably not going to be all electric, which was the hope of advocates. But it is better than the current stretch code in Massachusetts, and it's a direct result of local advocacy around building electrification. And in New York and Washington state, local interest in natural gas bans, among other advocacy, of course, has led to statewide efforts to require building electrification. Unfortunately, these haven't totally taken off yet. The New York State All Electric Building Act, even though it had the votes to pass, was the Senate leadership didn't bring it up for a vote, so it's dead for this session. I think the building code amendments in Washington are still sort of being hashed out / contested. Folks are questioning Governor Inslee's authority to make that direction. I'm sure there are probably other folks on this call who can speak to what's going on in Washington slightly better than I can. But again, this is something that's come out of advocacy by local governments and local residents interested in building electrification, advocating directly to the state legislature. Let me just look at the chat again quickly. Yeah, we'll talk about those preemption laws. All right. Okay. So other potential legal issues for your local government attorneys. This slide contains a few additional legal issues to consider. I won't go over them in detail because most of you are not attorneys, but I'll give Anne these slides. She can share them with you. And if you just want to bring them to your city or town or county's council when you talk about this stuff, that is fine. And they can kind of follow up on some of this stuff. But one point that I will highlight on this slide is the Energy Policy and Conservation Act, or EPCA, because this can have implications for building electrification policy. So EPCA is the law that's at issue in the Berkeley, California litigation that we discussed briefly. So, the EPCA preemption claims that are discussed by the California Restaurant Association in that lawsuit are pretty remote and speculative, but more directly, EPCA directs the federal government to set energy conservation standards for many common building appliances, generally, but in particular, some common building systems like furnaces and HVAC systems. And it preempts state and local governments from setting energy conservation or energy efficiency standards for those same appliances, with a few exceptions. Preemption, for anyone who's not familiar on the call, preemption is the concept of a higher level of law displacing or blocking a lower level of law. So federal and state law can both preempt local law or essentially prohibit a local government from acting in a certain way. So I just want to be clear, as you're thinking about a building electrification policy, your local governments, if you're American, if you're in the US, your local governments could not set a standard saying that HVAC systems, for example, had to meet a certain energy efficiency standard. That would be preempted by EPCA very directly. You also would not want to require that HVAC systems use only electricity because of that because electricity had better energy conservation properties as compared to natural gas. That would be preempted. There's quite a bit less certainty around electrification requirements having to do with air emissions. These are less likely to be preempted. We don't have case law on it, but that's not what's preempted by EPCA. There's also an exception for appliance energy standards that are contained in building codes, so long as the building code is drafted a certain way. Again, this is getting very into the weeds. You can share these slides with your municipal attorneys. I don't need to kind of bore you all with all of this. So, I don't think we have anyone involved in these joint policy efforts calls that's from one of these states in red. But in case there's anyone from elsewhere in the Safe Cities Network or NEOS on this call. So I believe it's 21 states at this point that have now passed very broad preemption laws that prohibit local governments from enacting natural gas bans or building electrification requirements. This is the result of very coordinated efforts by the gas industry and by legislative groups like ALEC that have shopped this kind of legislation to state houses around the country. And it means that in many places in the country, a lot of these red places on this map, it means that in many places in the country, local governments have little authority to do almost any of what we've discussed. Maybe they can get around it with some zoning stuff, really depends on how the preemption law is drafted. I don't want to make broad pronouncements because these laws vary very much in their details, but I'm happy to take questions on the call if anyone is from one of the states that has one of these very broad building electrification preemption laws in place in their state or is in danger of having one put in place. Needless to say, these laws really limit what local governments can do in this space. So that's what we have seen nationally on building electrification. I will take any questions in a moment, but I also just want to say I'm getting a lot of questions these days about West Virginia versus EPA, and so I thought I'd take like a 30-second detour before I close out. So for the non-Americans on the call, if there are any, we in the US are expecting a Supreme Court decision in the next couple of days, possibly tomorrow, that could significantly limit our federal EPA's authority to regulate greenhouse gas pollution. It's far more complicated than that, but that's kind of the headline issue of the case. So I want to be clear that, regardless of how this decision turns out, and it could be bad, but regardless of how it turns out, nothing about it impacts state or local authority to do whatever it is you're doing on climate. The decision might make it more difficult for your communities to meet their carbon reduction targets because the power sector is going to get greener slower. But the case has nothing to do with your actual local authority. And so I would encourage you to think broadly about your ability to act on climate, given what will potentially be somewhat of a gutting of US federal authority to act on climate. Okay, so that's really it. I'm happy to take questions either now or after our next speaker. Thank you. Thanks for having me. I will take down my slides.
Thank you so much, Amy.
So it's a good question. The CLCPA doesn't give any authority or take any authority away from local governments directly. I do think it makes kind of the moral case that you're describing or the practical case that you're describing, but it doesn't directly give any particular authority to local governments to undertake any particular kind of policy. I think, when you're developing local laws, when you're making your legislative findings, I think it's a really good idea to point out that in order for the state and in order for the town in particular to meet the goals of the CLCPA, the town therefore needs to do X, right? Undertake the kind of law that you're developing. But it's more of a, telling the narrative story of what needs to be done to carry out the goals of the CLCPA. The CLCPA doesn't directly give any authority to local governments. And I think that that's something in New York in particular that's going to kind of need to be addressed because there's quite a bit of uncertainty by local governments in the state of New York about their authority to do things like ban natural gas or otherwise regulate building emissions in a way that's pretty inconsistent with the CLCPA. So I think there's going to need to be some work to be done at the state level to clarify, or maybe just a brave local government to kind of go first and say like this is what we can do, this is what can be done, because I don't think that anyone kind of really thought through the relationship between the state and the local governments in developing the CLCPA. There is a local government committee or whatever they're called of the Climate Action Council. But I think they're kind of focused more on like land use and that sort of thing, and not as much on local government authority. I think you can think about that as you're sort of making your legislative findings and telling the story of why you're developing a law, but it's not necessarily going to have the legal strength that you'll need to like survive a challenge. You'd want to make sure that you had some other place you could point to have the legal authority to do whatever it is you're trying to do. And the CLCPA does not give any direct legal authority to local governments. So that's what I was saying specifically.
Of course. So
yes. Yeah, so in New York, there are a few legal issues to think through. I think that local governments do have the authority to do what you're describing doing. How are you planning to do it?
It'll be a code change, inevitably. The planning department and the code, it'll be a code change.
Okay, so I don't offhand know the ins and outs of updating the code from a local perspective. I know it's different whether it's the building code or the energy code, and so I trust that you will figure that out on your end.
Sure.
What I am going to put in the chat is a presentation I gave. It's a little old. It's probably like a year and a half old, for New Yorkers on clean power about legal issues specifically in New York State. And so you might just want to watch it. It's like the first 15 minutes of a webinar.
Absolutely.
But yeah, I mean, I'm bullish on this stuff. I think you can do it. There are legal issues to think through in New York. But I think if you can figure out the sort of how do we actually go about this code change, I think you have authority to do it. That's an incredibly complicated question. I would start by looking at any franchise agreements that you have to see what they might say about your relationship with the utility and their rights of way. If your franchise agreement is coming up for renewal sometime soon, that may be an opportunity to renegotiate. If it's not, you may be limited by what the franchise agreement says that you can or cannot do. But it's going to be very specific both to state law in Montana, as well as to your franchise agreements or any other agreements or laws that govern your relationship with the utilities. I've been doing a fair amount of work with local governments in Oregon. I think there are some legal pathways forward. None of them are kind of a sure thing. I think the kind of natural gas ban pathway is one that is there for local governments to explore. And I'm, spoken to a few local governments in Oregon who are interested in following it. I have been doing a fair amount of work with the Green Energy Institute at Lewis and Clark. They've kind of mapped out how local governments would request a building code exemption, like a local exemption to allow for a local amendment. They've also done some work around taxes and fees for fossil fuel use. I'm happy to connect you with folks that I've been working with in Oregon.
Okay, well, maybe I'll just invite Amy to close it out. Just closing thoughts based on the landscape that you're seeing and your work with lots of different local governments right now too.
Yeah, I think there's a lot of potential here. I think what I hear from local governments more than anything is uncertainty around how they're able to proceed. And so I think that by kind of understanding the legal frameworks that are applicable in each of your states, you can kind of help shape a way forward that works in your particular local and state jurisdiction. At the same time, I think, someone's kind of just got to go, right? Like someone's got to go first. And we will start to better understand these legal frameworks and opportunities as we start to see more of these policies move forward. So there's, an amount of work we can do to kind of get everyone as much information as they need to shape policies that are consistent with their state's legal frameworks. And then, I think there's a lot of latitude to be creative with these policies as we move them forward.
Thank you, Amy, and we agree, and we're excited. If there are first movers in places that there hasn't been a local policy passed in your state yet or by your kind of jurisdiction yet, and that's part of what we're hoping in the joint policy announcements in the fall, and just generally with SAFE to build some strength in numbers and see if we can help a few jurisdictions come forward at the same time, or just a few brave folks who are ready to call this question, because we've sort of had it drilled into us in a lot of different places that this isn't possible, and we need to test those waters a little bit, and we're really excited to help support you in doing that, either this fall or when the time is right. I want to thank you all so much for coming today. And Amy, thank you so much for presenting to everybody about this and also helping folks in lots of different ways across the year of this joint policy project. And thanks again for to everybody for coming today and for all the work that you're wanting to do to protect your communities and global climate. We really appreciate it.